Right. More court news, big news yesterday from the U.S. Supreme Court when they agreed to hear arguments in a case coming out of Mississippi. Now, the law at hand is the question is the 2018 Gestational Age Act, which passed in Mississippi, that allows for abortion after 15 weeks only in medical emergencies or in cases involving fetal abnormality. What this does is sets up the first major challenge to Roe v. Wade since 1992. When there was another challenge, which has been the prevailing judicial opinion since that time. Joining me now to talk about this is the man who actually signed this bill into law, former governor of Mississippi, Phil Bryant. Governor Bryant, welcome back to the program.
Tony, thank you so much. It's a great day to be on and good news from our Supreme Court.
It is, and I remember you and I talking about this when you signed it into law. And this is what you hoped would happen, that you would be able to take a stand for the unborn and that this might make its way to the Supreme Court and be the case that the court would take up.
Well, absolutely. Many of us, Tony, over the years have doubted Roe v. Wade, where it came from, where is it in the Constitution, particularly when you talk about pre-viability, 15 weeks and beyond. So And also, does the state have a compelling interest in protecting the lives of children? Well, the answer is, of course we do. If that mother is ingesting cocaine or other dangerous drugs, we might charge her with child abuse. If someone would fire a weapon and strike that child as a mother is pregnant at that time, we would charge them with murder or a homicide. But if you decide that you want to abort that child, then these organizations that stand against us say, well, it's not in the compelling interest of the state. You can't have it both ways. You cannot have a law that protects children in the event that some outside force would harm that child, but say it's okay as long as the mother consents. And so we believe there is a direct correlation between protection of the child, the compelling interests of the state, and what the case is that the Supreme Court has heard previously. And we are anxiously awaiting October, hopefully an October date.
The 1992 case of Planned Parenthood versus Casey, which has set the jurisprudence presently for the abortion. I don't want to say laws because they've not been passed by legislatures. This has been imposed upon states by the Supreme Court. But now with what appears to be a constitutional based majority on the court, there's a good chance that we could see the whole issue of abortion sent back to the states where it belongs.
Absolutely. And we think, of course, this is a states' rights issue. Do I have the right to protect unborn children in the state of Mississippi as governor? The number one responsibility of any executive, and I would dare say also legislature and judicial officer, is to protect the citizens. This is our constitutional responsibility, to protect the citizens of the state of Mississippi, particularly, we believe, our faith leads us to believe, that unborn child. So the court has these pre-viability abortion that cannot be challenged. So that's only existed again in case law. So we began to look at the entire scope of this matter. And does a state have a right and a compelling interest in the protection of the life of that child? This is what the Supreme Court will be hearing. We believe, obviously, it will be in the affirmative. I will tell you, our female Republican Attorney General, Lynn Fitch, did a remarkable job of presenting this case, this argument to the Supreme Court, after an Obama-appointed federal district judge turned it down and rejected it. After the Fifth Circuit Court of Appeals upheld that rejection, our determined Republican woman, Lynn Fitch, Attorney General of the state of Mississippi, fought a courageous battle to convince the Supreme Court to hear this case. I want to congratulate that strong woman who is in defense of the unborn child each and every day of her public service.
Yeah, I noted a quotation from her. She said, America cannot be a human civilized society if its courts preclude lawmakers from imposing reasonable limits on the taking of innocent life. She's aggressively defending, as an attorney general should. That's a breath of fresh air for you. You didn't always have that in Mississippi. And you've constantly faced Judge Carlton Reeves with laws that you passed. This has to be gratifying that this has gone to the Supreme Court. And I would add to this, Governor, I saw this when I was a legislator. People say, wait a minute, now's not the right time. Don't do this yet. We're not ready for this. And my response always was, it's never the wrong time to do the right thing. And I think
Absolutely.
This proves that point. Obviously, it's going to be a year before we get the decision, but it certainly has been teed up to protect the unborn all across America.
And I think as we talk about listening to the science today, Tony, that's exactly what we want to do. We want to listen to the science. We want to listen to see that child is suffering, the pain that child is going through. What about the threat of the mother? There's greater risk to the mother. Scientifically, we know this after 15 weeks. Yet the abortion industry that uses a dilation and evacuation process after 15 weeks wants to ignore that science. They want to say, no, that the circulatory system is not developed at this point, that the infant doesn't feel full pain after 15 weeks of this horrible dismemberment that takes place. Science is on our side, and we look forward to arguing this case. Now, these legal matters, not only states' rights, but the science of this particular pre-viability case before the United States Supreme Court. And again, our female attorney general is going to be there on the battleground fighting for the unborn.
Now, Phil, in the case that was previously before the Supreme Court on Louisiana's law regarding abortion clinic regulations, which I authored the first iteration of, this was a second, third generation of that law. You had two appointees from Donald Trump, Neil Gorsuch, and Brett Kavanaugh that went the wrong way on that to allow that law to go into place. Are you concerned about where they might be on this one?
We absolutely are. We've been surprised before by some of the more moderate members of the courts. But again, if you look at case law, and I am told by some of our finest attorneys in the Attorney General's office that the case here is clear. The state can prove, we believe, beyond a reasonable doubt that the state of Mississippi does have a compelling interest in protecting children. And so that is the heart of the matter here. And if so, then that authority needs to be returned to the states. And that's exactly why I signed this law into effect, because I believe the state had not only the legal right and the compelling interest, but the obligation. We are obligated to protect these children. And I think even the most moderate Supreme Court justice has to see not only the wisdom of the 10th Amendment, but the fact that the state of Mississippi was doing no less than we had to do for the compelling interest that we have of the unborn children that are Mississippians and are citizens of the United States of America, and therefore have the constitutional right to life and liberty and the pursuit of happiness.
Well, Governor Phil Bryant, again, I want to congratulate you on this landing before the Supreme Court. We'll be watching it very carefully as they have the oral arguments and then move toward a decision. But I know, governors, oftentimes they sign things because legislators pass them. But I know this is one that you were calling for, cheering for, and you have been a strong, strong advocate for the unborn and for religious freedom, I might add. And I want to thank you for your leadership.
Well, thank you so much, Tony. And thank you for letting everyone hear the position of Mississippi and what you're doing for the United States of America. God bless you all.
All right. Governor Phil Bryant, that's good news, not just for Mississippi, but for the entire nation, that this law now is going to be heard before the Supreme Court. It's every decade and a half or so, the court will take up, almost every 2 decades. If you look at it, it was 1973, Roe v. Wade. Then 1992, Planned Parenthood versus Casey. And here we are almost 2 decades later, and they'll be taking up actually 3 decades later, taking up this case out of Mississippi. So be prayerful, but this could very well send the whole issue of abortion back to the states. And then you see, you already have states that have acted upon this in anticipation of a case. They didn't know which one, but a case making its way to the Supreme Court, these trigger laws where states will immediately ban abortion once it is thrown back to the states to make that decision. And, you know, the end result is America is going to be a predominantly pro-life nation again. This is, you know, for years people have been praying, repenting of abortion. Well, repentance requires action, turning away from what we've been doing, and we're changing the laws. And this has been a holistic process. It's not just the laws that have been changed, it's the hearts and minds of people. Technology's played a role, science has played a role. The crisis pregnancy centers, the ministries that are out there caring for these women and these babies, that's been playing a role. Adoption, that's been playing a role. We're reaching a moment where we could very well see, in the midst of all of the other challenges, we could deal with this one issue, which I think is quite significant when you look at the spiritual, cultural, moral landscape of America.